Francis and Prudence, welcome to the committee. You have 5 minutes. I'm just going to set my little buzzer. Please do use that as you see fit, and we look forward to hearing your submission.
Kia ora koutou. Thank you for this opportunity to expand on some of our written submission, which we will take as read. You've heard from many disabled people of whānau on this bill, and their submissions echo what I've heard in my engagements. In the context of my statutory role in the Commission's mandate as New Zealand's national human rights institution, I'd like to speak to 2 concerns today. First, the responsibility of the state as the primary duty bearer to progressively realise disabled people's rights, and second, denial of access to justice. When ratifying the Convention on the Rights of Persons with Disabilities, the government agreed to act as the primary duty bearer. The principle of progressive realisation imposes a duty on the state to continually improve the enjoyment of rights by disabled people, including rights to dignity, autonomy, and being included in the community. Disabled people in whānau have advocated for many years, supported by court decisions, for a disability support framework that is not opaque, inequitable, or one-size-fits-all. This bill presents another step in the wrong direction. Instead of strengthening and clarifying access to supports to facilitate rights, it does the opposite. By reducing state responsibility to an unspecified contribution, it shifts this responsibility onto families. Families which the statistics show are consistently some of the hardest hit by material hardship. The state has an obligation to ensure active participation by disabled people in their whānau in decisions affecting them. This is not only crucial to upholding human rights, but also for ensuring that legislation and policy is fit for purpose for those it is intended to serve. Yet this bill has been introduced with no such consultation and subject to a tight deadline for submissions. This is wholly inadequate from both a human rights and operational perspective. While diluting state responsibility on the one hand, the bill also concentrates the power of the state and the minister on the other, enabling broad discretion over funding decisions and the ability to means test recipients without providing any guaranteed minimum entitlements. This is particularly concerning as it signals a move towards a welfare-type model where rights can be chipped away at over time. This bill creates neither certainty nor fairness. It positions disabled people as costs to be managed rather than as active rights holders and valued citizens. Neither the process or the content of the bill meet the Te Tiriti or human rights standards of active participation required for such legislation. This bill justice. Through overturning a Supreme Court decision extinguishing existing claims and banning all future claims of discrimination or employment-related breaches, this bill presents an affront to the right to justice for disabled people and their whānau. It is inconsistent with the New Zealand Bora and the right to non-discrimination affirmed under domestic and international law. It has been made with unnecessary haste based on an explicit lack of data to justify such extreme measures. The Supreme Court and many other courts before it have continually signalled deep flaws in the DSS system. This bill only deepens those flaws by entrenching discriminatory treatment of disabled people in their whānau and taking away their rights to challenge such treatment. While we recommend that this bill does not proceed at all, should it do so, I urge the committee to recommend that it gives explicit effect to the rights secured under Te Tiriti and the Convention, particularly rights to active participation and equity. That it clarifies that any support provided by families must be voluntary and complementary, not a substitute for state support, and that adequate minimum entitlements are clearly legislated at this initial framework level for both disabled people and their carers to protect against material hardship caused by persistently inadequate legal protections aggravated by the denial of their rights to justice through this bill. Kia ora.